Let's talk mediation. Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote awareness of mediation in the world around us. And to talk about mediation and other alternative dispute resolution systems from the perspective of a common person. We continue with a short legal disclaimer. The views expressed herein are the personal perspectives of the speakers and may or may not represent the views of the larger professional community they belong to. The conversation series aims to provide a general overview and awareness on the subject matter involved and may not be construed as a legal or professional advice in any manner whatsoever. The session is being recorded for wide circulation. And now let me introduce the lead speaker and the guest panelists who are going to contribute in today's conversation on family and human relationship mediation. We have Ms. Janice Bull as our lead speaker. Janice is a conflict resolution specialist, mediator, social worker, and child consultant with over 20 years of combined experience. Janice is a passionate about helping people in dispute resolution and whether it is in separation and divorce or in workplace. She aims at empowering people to have a voice, to be heard, and work towards resolution for a more peaceful future. Welcome on board, Janice. It's a pleasure to have you here.
Thank you so much. It's a privilege to be here.
Our pleasure. The guest panelist, Dr. Wasim Ashraf, child and adolescent psychiatrist. He completed his MBBS graduating from Government Medical College Jammu in India. He further completed his post-graduation in psychiatry from South London and Maudsley, UK. He has over 16 years of working experience in mental health services. He is currently working as a child and adolescent psychiatrist in the Type 4 inpatient setting. He has the special expertise in treating complex psychiatric conditions. He lives in Greater Manchester area with his 2 children.
Thank you so much. Thank you
on
so
board,
much.
Doctor. It's a pleasure, and it's early morning. We understand from London, but it's really benevolent of you to have joined us. Thank you so much.
Thank you, Sonal, for the opportunity. Thank you.
Ms. Bansuri Choksi, a brand strategist by profession with a keen interest in human psyche and conflict resolution. She's an avid reader, a once-in-a-year podcaster with a knack for everything that involves storytelling. Wow. In her words, my curiosity derives my action and its outcomes. Lovely.
Hello, everybody. Very nice to meet you.
We have Ms. Vanshika Maan, a third-year BA LLB student at Himachal Pradesh National Law University, who is a keen and avid mediation enthusiast and expects to accentuate her skills and gain expertise through this session. Wonderful. Welcome on board, everybody. We also have today Shazia Kausar. Shazia was previously there in our previous session, but due to some emergency, so she left early. And she's an advocate based in JNK, right, Shazia? Yeah. So let's continue with the session. First, I would request Janice to tell us about family mediation from the perspective of a common person. What family mediation actually means. Over to you, Janice.
Okay, thank you so much, Sanal. So family mediation in particular is when a couple have separated or divorced and they are in disagreement in some way around what happens next. So that might be around what happens with their children, shared care arrangements and other big decisions around with the children, and also too how they're going to divide assets, money and property. So that's where mediation, family dispute resolution in particular, comes into play. So it can help bring parents together. Sometimes they're not parents, sometimes they just might want to mediate property, which is fine, but it helps bring them together and have safe, supportive conversations with a neutral person who is the family dispute resolution practitioner, also known as a mediator. So really people come to the mediation with some issues that are in dispute. So we really help bring out what those issues are, and we give time and space for people to talk from their own perspective of why those particular points are an issue for them. So we encourage open dialogue, communication, transparency, respectfulness, respectful listening and communication. So not only do we help separated couples negotiate and come to agreements, but in my mediations in particular, I like to educate and model along the way too, so that it can help prepare people for the future as well. Because if they have little children, then this is not the only time that they're going to have to talk together and negotiate agreements. So I really help to also upskill those people with the lifelong learning and skills that they need to continue those difficult discussions. So I make that really clear from the beginning too. So we're not just here to talk about proposals and agreements. We're here to actually learn how to listen respectfully to each other and to problem solve together. And what we'll talk about a bit later, and that is about the co-parenting. So what I'm doing is I'm helping them skill up to co-parent their children together. If it's the property and financial disputes that they come to mediation with, then we help them establish what their asset pool would be. We help them understand what the contributions mean before, during, and after their marriage, and also to everything else that they would like to be considered when dividing their property and assets fair and equitably. So again, it's a different structured process. They are slightly different structured processes, the parenting and the property, but the philosophy is the same. So no matter what mediation I do, I always say the philosophy is the same. It is bringing people together that are in some sort of dispute, that feel that they can't otherwise have those difficult conversations for various reasons. So those conversations might go round and round in circles. It might be their conflict styles don't get along well, hence probably why they've separated too. So I really help break down those barriers, and it's teaching conflict resolution skills at the end of the day, no matter what mediation I do. No matter what it's about. It could be about anything, and the philosophy is the same. So that's in a bit of a nutshell.
Yes, that's really too much in the nutshell, but so now, that's really good, actually. We need to know that. Now, I was understanding that educate and model adults how to respect, because when there is a dispute, that respect is something that really goes away from human relationships, and that to establish that for a mediator in the mediation room, the anger also, and like you said, the merry-go-round that's happening, round and round in circles. And so how does Janice manage that, to bring them to a level of trying to work together as a team? How does Janice manage?
Yeah, so creating strong foundations in a mediation is the absolute crucial key. So the foundations have to be strong. So the pre-mediation intake session that you do individually with people creates very high expectations and educates them of what is expected of them, what's expected of the mediator, what's expected of the other person. So I talk about respect from the very beginning, and that is back to basics of even what we teach children. Is when someone is listening, we do not interrupt them. We let them talk, we let them finish. Even if we don't like what they're saying, we let them finish and we don't interrupt. So that's mediation 101, is do not interrupt the other person. If you have something to say, you write it down and you will get your right of reply. So it's teaching those skills that they've lost along the way. And it's because what you're doing with making them pause and not interrupt is to listen. And then it's also too with the skilled questioning of the other person is to bring out what did they hear that other person say. Because a lot of the time too, we think we hear what we either want to hear or what we assume that we hear, and we fill in the blanks. Oh, he's really saying that I'm this, that I'm A, B, and C, or she's saying that I'm, and I'll say, hang on a second, what did you actually hear?
Yeah.
So I'll actually make them even just repeat back what they heard. And even just getting them to do that exercise can create acknowledgement that that is a different perspective. And also then the respect comes later. So sometimes if the emotion is too high and there might be a lot of hate and anger, Respect might be too much. It might be a trigger word for them. It might be too much to ask. So I ask for just, then I reframe it to respectful listening then. Okay, because respect, it's a funny concept to people. It can be very valuable to some and not valuable to others, and it means different things. So I just get back to basics with the behavior then, and we're going to behave respectfully, which is even the ground rules of no swearing, no aggression. Even if we're on Zoom, please do not roll your eyes or huff and puff. We can see it all. So it's getting the ground rules. So I have very strict ground rules that I share at the beginning of a mediation. I make sure that everybody is committed to the rules. And I also let people know what I might do if I don't feel like they're abiding by the rules. So I might do things like I might interrupt them, or I might, even if it's escalating, I might put my hand up and say, stop, pause, or I might just break into a breakout session quite quickly and address that behavior privately. So I really drum in the behavior. So what is respectful behavior? That is really, listening's the hardest skill they have, because they're not used to doing that with that particular person. They can do it in their workplace, they can do it with their friends, but with that particular person, respect has gone out the window on both sides, and it's hard to get that back. So sometimes I talk about it in a different concept rather than actually respect that person. I ask them to just behave respectfully.
So I think the pre-mediation session that you talked about would really make a lot of difference.
Yeah, it's the most important part, I think, is some mediators don't do it at all, or they do a quick half hour. My pre-mediation intakes are 1.5 hours. Sometimes we might go over that if we need to, because again, I'm not just getting their history or their story, but I'm educating and modeling of what's expected of them. I give them negotiation tips. I encourage them to come in with a problem-solving hat on. To not come in just with with the black and white thinking. Really encourage thinking outside the square. So I get them thinking and get them to prepare for their mediation, and the outcome is much more successful because of that, I believe.
I think
Now,
I'm sorry. Go ahead.
Yeah, I'll ask your views. Before we move further, we have to ask Dr. Wasim to step in here. When family and there is a lot of disintegration in the family, there is a lot of turmoil in the family. What is happening to the kids here? The impact on kids and adolescents. It is very important to understand that from a perspective from Dr. Wasim, from the perspective of a child and adolescent psychiatrist. We'd love to know your views on that.
Sure, Sonal, thank you. Janice, I don't envy your job. I can imagine the emotionally charged situations you go into. You must be very brave. I really appreciate that.
Oh, thank you.
Yeah. I suppose globally, it's often mentioned that child has to be at the center of everything, and things should be geared up around the child. But I think it's really important, and thank you, Sonal, for inviting me to understand the significant impact on children when they are placed in the midst of this conflict. I will try and refrain from going into the lecture mode and giving you data and statistics and figures, and I will try to give a general overview of the common problems that can be encountered if the child is in the center of conflict. Broadly speaking, any child who is placed in this situation where two primary caregivers, usually the parents, are in this state of conflict, there can be verbal conflict, there can be physical violence, which can then impact on the child in terms of their emotional needs not being met, and in worst cases, even physical neglect can occur. But broadly, we can put all of those experiences for the child in the category of adverse childhood experiences, which are commonly called as ACEs. And there's a lot of literature, a lot of research has been carried out, and there's a massive evidence base that a child having to go through adverse childhood experiences, the ACEs, it can have a significant impact, not only in terms of the risk of developing potentially serious psychiatric disorders, but also the child's ability in the future to function as a well-adjusted adult. The impact of ACEs can result in understandable disorders like post-traumatic stress disorder, if the child is exposed to significant strife and conflict within the family context. And now it's well understood that the post-traumatic stress disorder, sometimes it's not only the consequence of a major event like somebody being in a house fire or a gas explosion. Even discrete events over a period of time, which can be traumatic for the child, can then eventually have an outcome of the child developing post-traumatic stress disorder. Unfortunately, in my practice, I often see children and young people who end up having post-traumatic stress disorder. And when we look back into the developmental history, we will find that there is usually strife and conflict within the family setup. And when we talk about post-traumatic stress disorder, I'm sure we are all aware it's a debilitating, serious psychiatric disorder, sometimes needs treatment over a number of years, and the outcomes are still not that great. Young people, because of exposure to ACEs, can also have what we now know as complex post-traumatic stress disorder, where alongside the post-traumatic stress disorder presentation, young people can end up with self-injurious and self-harming behavior, self-destructive behavior, which takes the form of self-mutilating by cutting, headbanging, tying ligatures, and sadly, some of the time, very strong suicidal thoughts and urges, and then leading on to, unfortunately, mortality. There is some evidence to suggest that exposure to ACEs in early childhood can also be linked to developing psychosis later on in life. Now, psychosis, we know, is a severe and enduring mental disorder, which can be treated but not cured, with variable outcomes even after treatment. There has been found a causative link between early childhood experience or exposure to trauma and developing psychosis later on down the line. Some studies have also found that there is a 2 to 4-fold increase in drug use if a child is exposed to ACEs. So that's a child is 4 times more likely to abuse drugs in the future if they are exposed to early childhood adverse experiences, which is a significant number. We also see a high percentage of young people being diagnosed with personality disorders in this group of young people who have been exposed to early adverse childhood experiences. And oftentimes, people with PTSD in their adolescence, once they are adults, can be diagnosed with personality disorder. So I suppose there's a whole range of psychiatric disorders. And even if it is not a psychiatric disorder, there is psychiatric dysfunction, which might not meet the criteria for a formal diagnosis, but still creates psychological and emotional distress, which might not be a treatable mental disorder. But the burden of a child being in these conflict situations is quite significant. Unfortunately, we can't go back in time and rewrite the child's history, but I suppose the efforts of professionals like Janice and others who do a brilliant job in trying to avoid it getting to that point in the first place is something that is really beneficial to the child and can't be ignored. in terms of very briefly touching on, Sonal, in terms of you mentioned co-parenting
Yeah.
and how that as a concept can benefit the child. If we take away a number of things like Xboxes and PlayStations and fancy iPhones, human needs are very basic. A child needs a loving, nurturing, caring environment where their emotional needs are met. They are free from abuse. And any model that enables the child to have that, whether it's co-parenting, whether it's single parenting, as long as they are not exposed to the toxicity of a conflict situation, the outcome for that child, not only in terms of not having a psychiatric disorder, but also general well-being when they are grown-ups, is quite high. So whatever model we look at, whether it's co-parenting, single parenting, or any other variation of those models, as long as the child is not exposed to what I described as the ACEs, the adverse childhood experiences, the outcome for the child is inevitably going to be better. So that, in a nutshell, Sonal, is sort of the overall impact that you might see on children who are placed in these conflict situations. So I do apologize. So please feel free to interrupt me. I do get a bit carried away and I can't shut up. So I'll just shut up and hand over
No,
to you.
that was really necessary. Now we had Banjari trying to talk, Banjari, from a common person's perspective. Whatever you heard right now, you heard Dr. Wasim talk about early childhood trauma. You heard Janice also talk about how she's helping people rebuild their lives and respect, which is most important, because when there is conflict, you the first thing you lose is respect for the other person, respect for the family system. What I would like to you to be talking about is, when there is a family, there is a family and you have a family system, there is love, there is respect in the system. Now when that goes away, now when the family disintegrates, the child who is, who till now had a loving blanket around him, is now suddenly exposed to insecurities, to confusion, to fear. What is your opinion as a common person, as a totally person not in the legal, not in the mediation background? And what's your opinion? Let's hear from you.
Uh, so I think my mother has been a teacher and she's taught for about 20 years. She used to primarily take care of students from the age of 3 to 5. And I was always a curious child, so I always used to ask her, ki, Mom, so tell me, how was your day? And I know every year in the 20 batches that she taught of kindergarten kids, she had at least 2 to 3 kids who were different. And she always used to figure out from meeting their parents or from the conversations that she had with the kids that something was not right at home. So, right from a very early stage, I realized that conflicts at home, especially between the two parents, had a huge impact on the children growing up. And I remember she used to tell me that she had a child, a student who was just 3 years old, and he had a very probably a violent streak towards his peers in the kids around. And my mother always wanted to figure out what caused this. Why was a 3 year kid doing what he was? Where was he learning this from? So she asked the parents to come and meet her and realized that the mother had a black eye. When she came to meet my mom, she had a black eye. And so, I mean, that impact on the child was very drastic. And in fact, even if I look at the people around me, the people that I talk to, the people who are there on my podcast, it is kind of not easy to figure out because they also develop kind of a mask in the conversations that they have. But their whole personality is altered because a conflict wasn't resolved in the beginning itself. And plus, I also wanted to, I was just trying to say to Janice that um, so the pre-mediation, what she was talking about, the session before the mediation, is I think as important as a session between you go scuba diving, because your life literally depends on it. It's literally as important. So even if you don't pay attention to what happens during scuba diving, it is very important to pay attention to what they're telling you before scuba diving, because then only you can actually go into that activity. So yeah.
That's a
That
great
was,
analogy. I
yeah,
like that.
yeah. Even I was to carry on, Janice, because even I was amazed at that's quite apt for a pre-mediation, that pre-scuba diving, because they are diving into something that is they are not sure of, they are not aware of, and then if that training that actually helps them, that's a lifesaver to, or at least a few moments or a few hours or few sessions saver for them. Janice, you were saying something.
I was just going to say, yes, just a lot of people a lot of people say, I don't know what I'm doing. I've never done this before. And, I'll say, well, why? Well, that's kind of a good thing that you've never been in this position before. So how would you otherwise know? So it's very much the education is, I think, yeah, a big part of mediation between parents.
That was really a good example, Banjani. That was really good. So when Vanchika, do you have any input? As a law student, you are, legal aspects, especially when Banjari was talking about that black eye, that means domestic violence. So, well, our laws are they able to handle domestic violence? Are they do are they doing justice? What's your opinion about it? Then we'll ask Shazia's opinion also on this.
I think that when we consider mediation, very court-based process, like the judiciary has a lot of involvement in it, and considering that we do not even have a proper act for it, there is a bill has not been passed yet. So as Ms. Basari rightly pointed out, domestic violence is a big aspect of a lot of marital relationships in India, and it is a problem we as a country and society are facing. And when we see that and compare it to the legal aspect, I as a law student feel that a lot of times, even courts, and I would compare it to the sociology of the society, because when the courts consider cases, even which are related to domestic violence, in cases of divorce and separation, they often send them for mediation, which should have been sent to criminal charges. For example, there's a section 498A in the Indian Penal Code, which specifically talks about domestic violence, but such cases are sent for mediation, which personally I think is not a very good thing to do, because they should be criminally charged. But that again, the mentality that a marriage should always be saved instead of broken down, even when the women or even the men in the marriage are feeling suffocated, is something that is associated with us as a culture. That is something that needs to be changed. Again, talking of the legal aspect, Sonal, I think legally we need a lot of development in this field. India is particularly lagging behind when it comes to mediation, considering we do not even have a full-fledged law. All the laws, I think, specifically talking about family mediation, comes from judicial decisions in India, which I think the judiciary has taken us so far. And domestic violence, child support, and that I think domestic violence and child support are the two main things that form the part of mediation. As Sonal rightly pointed out, co-parenting is something that people do not even start to consider in India very easily, because they think that two spouses, when they've separated, they cannot co-parent. That goes against nature. There is something wrong, I would say, or something that needs to be changed with us as a society. So I think that's it, Sonal, for the legal aspect of it.
Yes, and I like the word that you said, cultural sociology. You was talking. Even I feel cultural conditioning of our as us as a race, as a human race, has been a little lagging behind to to bring these aspects. And you rightly pointed out, saving a marriage at the cost of human life is what cultural conditioning has brought this kind of an environment in our society. And we as individuals, where we are far away from co-parenting, because we cannot even think of two people separating and then remaining uh, correlating each other and remaining uh, pally with each other for the sake of a family. So here we also come back again to Janice. When the family is disintegrating, when things are going, first finances are going to be handled, then emotions are being handled. So as a mediator, how do you handle both the things? And then how do you help children? And what is co-parenting? For us, co-parenting is a different concept. So if you could just elucidate what you do actually, or how you handle that in Australia, we'll really appreciate that.
Yeah, so the family dispute resolution process, a lot of people now are doing what's called child-focused mediation. Pardon me. You've got child inclusive mediation, where you can include the children and they have their own private consultation with you, and you can give constructive feedback back to the parents of how that child is coping in the separation. So that's an incredibly powerful model, but we're behind the times in Australia and we're not doing that well enough either. But that can be really fantastic. The main one, though, if we can't do child inclusive, we do child focused. So that is putting the child at the focus of the mediation. So that's, we talk always about the best interest of the child, but we actually bring the child into the room without them being into the room. So you can ask the questions of the parents of how do you think that makes your child feel? When this happened, where was the child? What was happening for them? How do you think that was affecting them? Are you seeing ways that it is affecting the child? And it's again education around how conflict influences children. So I again create the foundations in the mediation to say this is going to be a child-focused mediation. So if I, as the mediator, see something that I do not feel is in the best interest of the child, I'm going to name it. Sometimes, depending on the situation, I might break into private session and name it privately because I don't want to blame and shame anybody. So you can have a private confidential conversation with that parent. But sometimes, if it's appropriate to do so, I will say, look, I'm just going to put it out there. And what you're talking about right now is not particularly child focused for these reasons. And I'll give some specific reasons why it's not child focused. What I do to create a child focused environment straight away within the first conversation of meeting somebody, because a lot of the time they will say, my rights as the parent is to see my child. And I'll just have a gently challenge that concept and say, I'm just going to gently challenge that. And it's actually your child's rights to see both parents. So in Australia, parents don't have the rights, they have the responsibilities under the Family Law Act, and the children have the rights. So I just gently challenge that, and I say, and they get a little bit defensive sometimes, and I say, look, this is the lingo of the language, that this is how I'm going to talk, that it is the rights of the child. So even when it comes down to when they say my time, my weekend, my time, I'll say, oh, just a child focus, reframing your child's time with you on the weekend, your child's weekend, and I just, it takes a lot of reframe. And then by the end, generally they're saying my child's time with me, rather than my time with the child. So that's a basic thing that I do to make it a child-focused mediation. And so that can really help, again, ground the parents to put the children first in any decision that they make regarding the children's, future decisions, but also their choices in their behavior when the
Yes.
children are there and when the children aren't there, like talk about leading by example, every single time, even if it's not reciprocated. that's how, things like that. And that's how I really try to make it a child-focused mediation.
I really like that it's the children, the parents don't have rights, they have responsibilities. That statement really goes a lot of way to make and show the difference how things are going to be dealt. So that really, in one word, that's the catch line. I think Dr. Wasim had his hand up. Dr. Wasim, would you do?
Thank you, Sonal. It was specifically around what you just mentioned around parental rights and responsibilities. We have a similar law, the Family Law Reform Act in the United Kingdom. And it struck a chord with me, Janice, because we often get dragged into situations where it's children's rights versus parents' rights. For example, a child of sufficient maturity might not want certain information shared with their parent.
Yeah.
And then I have a parent who is like, I have got rights. I want to know. It's about my child. And it's a legal, moral, and ethical minefield to navigate that. Because whilst you appreciate that the parents might be coming from a really good place and might have the best intentions of the child behind their requests, but at the same time, to balance that with a child's rights can be quite delicate, Janice, I suppose. But the legal setup in the United Kingdom, the parents do have rights. PR is a very important concept within the legal sort of framework. I also, Janice, wanted to briefly ask you, without putting you in a spot, issues around confidentiality, and are there occasions when you might be forced to override sort of confidentiality if it comes to light that there are some concerning facts that are brought to your attention during those sessions, and how would you handle that?
That's a
Yeah.
fabulous question, actually. Confident.
So yeah, under the Family Law Act, again, with family dispute resolution in particular, there is the the confidentiality definitely comes into that. And again, I explain to people that our conversation today is confidential. The only time that I, as the mediator, need to breach that confidentiality is if there's any talk of risk to harm to the children or to yourself or to anybody for that matter, or any other criminal behavior that's going to cause harm to somebody else or damage property. So I have that conversation in the intake pre-mediation session, and I reiterate that that confidentiality spiel at the beginning of their mediation. So they're very well aware that anything that is disclosed that's of particular seriousness of any risk or harm to anybody for that matter, I am mandated to report that to authorities. I have found, and I've done counselling for 20 years, and I have found that people don't withhold information because of that. They feel supported and held in that space to be able to disclose if they need to. So unless, but obviously I don't know if people haven't disclosed, but I haven't found that that's shut people down or that they haven't wanted to open up and talk. And there hasn't, if there has been a case where I have needed to disclose that information to anybody, it wouldn't proceed to the mediation anyway. So that pre-mediation intake session is assessing appropriateness. If there has been significant family violence, whether that be physical or a psychological or any kind of family violence, that I assess that along the way and make sure that if people, the main thing I look for is that if people do not feel that they can make their own decisions or speak up. So there can still be family violence present, but it doesn't necessarily rule it out all the time for mediation. We can create a safe, supportive environment. So Zoom is fantastic. We can do shuttle on Zoom. If it was face-to-face, we do the staggered arrival. We can do it in different rooms. There's all sorts of ways that we can get around that. What I mainly look for is that people can, they're free of any coercion or pressure or threat to make decisions and speak up. That's what I look for when assessing appropriateness. So yeah, there actually hasn't been a time in all my time in mediation that I've had to disclose any risk or harm, which is great. Yeah, but there's definitely is parameters around that.
Yes.
So just one more thing with the child consultation. Sorry, I just wanted to say what you're saying before around the children and confidentiality. So the child inclusive process is strictly confidential. So the children have the space to talk in privacy and in confidence, and to give feedback back to the parents. I ask permission. So I will frame it in a way and say, do I have your permission to say this to mum or dad? And if they say, oh no, I don't want them I don't want you to tell them that, I'll say, what about if I worded it in this particular way? Mum, when I talk about dad and you roll your eyes, that makes me feel sad. You know, just something as simple as that. That they say, yeah, say that. So it's getting that permission, but I love the process because of that. And if the matter goes to court, then confidentiality is out the window, and it's not great.
So that was really nice that you are actually trying to make that thread that has gone, the respect that has gone, come back. If
Yeah.
I can say that, to
Yeah.
parents, to the disintegration of the family has happened. Now they work together as a team, and you are just, like, if I may say so, like a coach, guiding them to a position, because when they come to you, obviously they are not in the best of their emotional intellect.
That's right. Mm-hmm.
So you are just trying to, that healing of the wounds, and making the strings more, if there are strings, then making it into a light rope so that they can still carry on. Maybe not the family system, but a little more like a family system. So that's really fabulous. I would like to call Shazia's opinion also. When we talk about the legal system, the law, and we go to the courts actually do not understand the feelings and the emotions. So how would you differentiate, and how would you rate mediation vis-a-vis the court for the family disputes? Let's have your opinion on that. You're on mute. You're on mute. Yeah.
Okay, am I audible now?
Yes.
Okay. Thank you so much for giving me the opportunity, ma'am. Talking about the concept of mediation, see, mediation is not something new in India. It has been since ancient times, like we had panchayats in India. So, but it didn't have the legal force. But now we, as we really need a strong legal, we really need a strong law when it comes to mediation, because even as an advocate, I feel this, that when it comes to family matters, there should be strong laws in mediation, because once police is involved, the reputation of the family is at stake. We know this thing. And in India, when it comes to reputation, we are more concerned about our reputation. So I agree that in law, emotions are not there, but we all know that the purpose of any delivery system, judiciary, the purpose of any judiciary is to afford quick and affordable justice to everyone. So though the emotions are not involved, but the purpose is to provide justice to everyone. As the ma'am, she was talking about the incident, that black-eyed incident. So domestic violence, when it comes to these situations where domestic violence is involved, definitely I believe that mediation should be there, because normally in India, women are not educated about a lot of things. They are made to believe that if you're facing violence, if you're facing any domestic violence, that is your right. You should take it. As a woman, you should take it. We need to educate women through mediation that no, you should respond, you should speak up against violence, you should speak up for your rights. So as an advocate, I strongly believe that mediation should be there to educate not only women, but yes, co-parenting should be there, that yes, once if you'll come out of this toxic relationship, when you'll come out of this toxic marriage, it's not the end of the world. No one is going to hate you. If in India we have that the stigma of divorcee. If a woman is called a divorcee, she has to face the wrath of the society. So I believe that we really need strong mediation laws. Though though the Supreme Court normally now in every court we have the mediation centers, but we need more and more. We need to develop this culture of mediation in our country so that whosoever is in a toxic relationship isn't afraid of the stigma which they'll suffer from the society. That if once we're given the tag of a divorcee, or once we'll go to the mediation, everyone will start hating us because we are not living according to the terms and conditions of the society. So I believe that mediation is very, very important, and we need good mediators. We need good qualified mediators. We need strong laws, or we need academics, education centers to educate advocates about that about mediation, so that whenever a client or whenever a person is coming to them, they are full-fledgedly able to advise them and guide them, ma'am.
Yes, very rightly said. When we were talking about cultural conditioning, we were actually talking about that, because when you are a separated woman, so for women you are either a husband snatcher. For a man, in a society, in a closed conservative society, you are an opportunity. That's what how women are seen. When you walk out of marriage, either you are a homebreaker or you are an opportunity. That stigma still remains. So cultural conditioning is very important. Now, when she was talking, Janice, I was also talking about, I was thinking about enforceability. Enforceability is one thing that comes to mind to a common person when such a situation in a family happens. Enforceability of mediation, vis-a-vis when you get a legal decree, then you are more confident. People are more confident to go through the law process because they will get an enforceability. Now, when we on in your opinion, according to from the common person's perspective, what is the enforceability of a mediated agreement? uh, let's Because this is a part of the knowledge gaining process for a common person. So let's talk, because that kind of hitch should not be there, that enforceability one. Let's talk about that.
So you're asking around so the agreements that come about from a mediation, how is that enforceable?
Yes.
Is that what you mean? Yeah.
Yes.
Okay. So when you come to your agreements in a mediation, I'm just thinking of how to best explain. So when you come to agreements in a parenting mediation, you document the agreements. It's called a parenting agreement. When those agreements are signed and dated, it's called a parenting plan. So the parenting plan is the heavily weighted document. It's not legally enforceable as such, but it's the only admissible part of a mediation. So mediation is confidential, which also means it's without prejudice, which means it can't be used as any evidence in court. The only part that can be used as any evidence in court is a signed and dated parenting plan. That's the only part. So it's not enforceable as in if one of the parents withholds one of the children, they can't go to the police and say they're withholding my child, you've got to do something. They will say you need to go to court. So they cannot enforce those parenting plans.
Okay.
So there's some limitations, but again, because I create strong foundations, I talk about the utmost importance of following this plan in good faith. You are coming here to this mediation, you are spending the money, you are coming here and coming to these agreements yourself. It is so important that you stick to them. And I find that people generally do. Sometimes they don't. But so I actually had a call just today, and she said, he's not going by the parenting plan. And I had a look and I'm like, oh, it's signed and dated. I said, that's very naughty of him to do. And you know what? It's probably best that you do need to take this to court now, because it's signed and dated. It is admissible as evidence, and it does mean something. A court does not appreciate it when this parenting plan was only signed in August in 2022, so it's fresh. They just don't appreciate that you've gone to the effort and made these agreements and you've signed and dated it. And so sometimes I believe a court will either enforce it and make it into consent orders, or it needs to sort of be reviewed and had a look at. But in the interim can be made, that they will actually make them, legally binding orders. I don't know that specifically, as I'm not a lawyer, but from a mediation perspective, that that is that's how they can be enforceable. But especially when children are so young, it's not always encouraged that you go and make it into a legally binding consent order, because it makes it more difficult to change. So we have a bit of a rule of thumb that when a child is little, your parenting plan needs to be updated and revised, reviewed every time they change a shoe size.
Okay.
So that's quite often when kids are little. So that gives an idea of how this needs to be a fluid document. But if it's signed and dated, you do need to stick to it and use it as your default. So parents might do the hard work and do their parenting plan, and that's great. But then they actually are getting along better because their communication's improved, and they can continue doing whatever they agree to do. When in doubt and when in disagreement, you come back to the plan. So I sort of encourage that too. Like, this doesn't, because then you can have people using the plan in a non-spirited way. So they're not in the spirit of the plan, because if they're, and that they can be rigid and inflexible, so if changeover time is 5 p.m. and one parent is late or says, oh, hey, we're having a dinner, can I drop them off at 6? And he says, no, the plan says 5. They're not being in the spirit of the orders, within reason, of course. But that's what they're there to be used in good faith and in good spirit. And that's, yeah.
So when we talk about enforceability of mediated agreements, that could be a lacuna or a lacking side for people to prefer mediation. That's what
that is
I
true.
believe.
They say, why would I bother when it's not legally binding? That is a barrier. Yes, it is. But again, I say, well, if you're wanting to make them into legally binding orders, come and do the hard work in mediation. Don't slog it out in court. Come and do the hard work in mediation, and then take them to your lawyer and they can make them legally binding. That's fine if that's what you want to do. But if you start going down court path, there's no going back. It's very detrimental to any concept of co-parenting in the future. The likelihood, if you go through to court and go through to trial, the likelihood of you being able to co-parent effectively in the future is really diminished.
Yes. So that brings us to the point that when you are having a co-parenting plan, that is flexible, first of all. Secondly, that was very important for everybody to know, because kids, when they are growing up and they go to the college, there has to be a revision of whatever has been decided as far as co-parenting plan is concerned. But when we go to mediation, the decision of finances, when you talk about the finances and distribution of finances, when the marriage disintegrates, those are legally enforceable, right?
Yes. So the agreements that they come to, so unlike parenting agreements, the financials must be legally binding. So if you've gone to the effort and done your financial agreements within mediation, again, we give those heads of agreement to the participants, and they can take it to their respective lawyers for their independent legal advice, and for that lawyer to draw up those consent orders, and the court can review and the court can stamp those orders. That is a must for financial property settlements. Because if you don't, you're leaving yourself very open and vulnerable to future disputes over the finances. So that's highly recommended that people do that.
So, like what you are doing in Australia, I could understand that first it is a mediation, they agree to certain things. Then the court, the role of the lawyer comes up, who drafts an agreement, and then that is stamped by the court, and then it becomes a legally binding document. Right?
Yep, that's exactly right. So that's one. So there's two ways in your financial and property settlement to make it legally binding. So you've got your consent orders, which is what you've just described. But sometimes the other way, because the consent orders come under the scrutiny of the court. So the court must review them and make sure that they're fair and equitable and that all looks good. And sometimes people don't have a lawyer. They don't have legal advice for consent orders. They might do it themselves. But again, if the court reviews that and that looks fair and equitable, the court can approve that. That's one way. The other way that doesn't come under the scrutiny of the court is called a binding financial agreement. So if people come to agreements, it's a bit outside the square, not your usual type of agreements, could be a bit more complex. They can go to their independent lawyers for independent legal advice. the lawyer must sign off on that, and then they can draft a binding financial agreement. It's not under the scrutiny of the court. So you can be a little bit more outside the square, a bit more creative with those agreements. But as long as you've had independent legal advice, sometimes the advice is don't do it. But as long as they've signed the form that says I've given advice, and they can, structure that advice and give that advice to that person so that they can back themselves. The person, if they want to sign that, then they do, and that makes that legally binding as well. Generally, the more preferred method is consent orders under the scrutiny of the court.
Yes. So that gives us the flexibility aspect also. But
There is that. There can be some, I did a mediation once, a property mediation, and there was no disclosure. So the male didn't want to disclose any documents, which is very unusual and not recommended at all. But the wife was accepting, and she was trusting of that, and she actually didn't insist on disclosure. And so as much as we tried to educate and the lawyers advised, he never provided any disclosure at all. So if that was to go through the court would not approve that and say, no, there's been no disclosure, we're not approving that. Whereas a binding financial agreement, they did. The lawyer advised against it, advised her client, I advise against this because there's been no disclosure. You don't know what he's hiding. And the client didn't take that advice, and it went ahead. And that's what can happen sometimes.
Yes. So that brings us to the beauty of mediation, that you can chart your own course. You can think, because your relationships are more important than, what understanding you bring to on the mediation table is more important for you. So if
Absolutely.
two people are agreeing to, having that, that she's not willing to understand what, she's not willing to know what he's hiding, and she's agreed. So, that gives us the flexibility, the mediation aspect of it. Then,
with that particular one, she just didn't care. She's like, he might be. I couldn't care. She was an independent woman. She had her own assets. She had her own money. They, they were married later in life. Their relationship was around 10 years. She couldn't care less what he had. She just wanted the financial split to be done, and she was going to walk away with her stuff. He can walk away with whatever he wants. But a court wouldn't approve that. A court wouldn't do it. But a binding financial agreement can. So it can be more flexible and think outside the square for those particular cases.
that has been a fabulous learning experience, because what you guys are doing there and what we are, because we are still in a process. Yes, mediation is definitely around the corner for India. Conciliation has been around, and legally binding agreements are valid and quite enforceable as far as conciliatory agreements are there. So, as pointed out earlier, also. So, I think that was a fabulous learning experience. Any opinions from anybody, Bansuri, Shazia, Vanchika? Yes.
I actually have a question, and I'm going to ask it at the risk of sounding naive. But after this conversation, I've realized that when it comes to India, so in India, people either stick to the abusive relationship, or they completely they part ways. So there's just black and white. And I think mediation is the gray area where, in a good way, the gray area in a good way, where people can Indians can kind of figure out that there's a solution to whatever they are going through. So, but as a common person, I know people around me probably are not really aware about mediation. So, where do we begin that first step of introducing Indians, people like me, and people around me to mediation? What is the first step to introduction of mediation in a country like India?
Probably the first step that we are taking is introducing it. But yes, we would love to hear it from Janice. How you have pulled it, how your country has, made it such a streamlined thing that, it's.
Well, look, I guess sort of it is sounding more streamlined than what's happening in India. However, we still have a long way to go too. So I am still so surprised at the number of people that still don't know about mediation. So that is very common too, that people didn't know that this is an option. So we still have the mentality that when you separate, you go to a lawyer. You go to a lawyer, you go to court. They're like, what's this mediation? I don't want to have to talk to them. I just want it to be sorted out. So it is still, I think, a new industry as well and concept. And similar to what you said, Shazia, around mediation isn't new. What I'm hearing and learning more about is that in every culture in every country, they've had their own way of sorting out problems that aren't violent. So we have, in Australia, we have our Indigenous people that have sat in healing circles for thousands and thousands of years. So that is when there is a problem and a dispute, that they will get the elders of the community to come and help, and they will sit down and talk it through. That's basically all we're doing. So it's funny how you think about it like that, yet people are just like, what is this problem solving approach I do, and I think that comes down to the education of young children in schools, starting as young as preschool and kindergarten, around conflict resolution.
Yes.
So one thing that's coming up more and more and more is this restorative practice that's coming into schools, restorative justice into the justice system. So it's the concept of people coming together that are in dispute. With restorative practice, it is more so when one person has done the wrong and one person has been wronged, and we can bring them together and try to sort through it if it's safe, appropriate to do so. But what they're doing in preschools is they're sitting in circles, they have their talking stick, and they're talking about feelings, they're talking about problems, they're starting to equip children with the language that they need to solve conflict. So I believe this is the answer
Yes.
that we may see in years to come, but I feel that even myself, I was absolutely not equipped to deal with conflict, and I will avoid it myself when it's in my personal life. I will avoid it like like anything. I find it very difficult, to be able to have tough conversations. So, and I'm in the industry, so we're not trained, we're not educated on how to actually deal with conflict itself. So I think that's, if we can get back to those healing circles, I think there's definitely more hope.
Yes. Yes. So it's actually going back to those systems, those, like Shazia told about panchayati systems, like village elders, trying to sort out things. Yeah,
Can I just
Shazia.
mention a point here, ma'am? See, I feel that whenever a party where they're going to the court, I feel the judge should first ask the parties whether they try for mediation or not. That's a very good step towards mediation, for the promotion of mediation, ma'am. This should be there.
I think that's in India is coming up, and it is going to be mandatory now. But
We need to develop this culture of mediation, ma'am.
yes.
Yeah.
And that's globally. That's really globally. So it's really a wonderful conversation that we've had, and I'm sure it's going to make a lot of difference to tell people, let them understand what mediation is, like Janice told, and co-parenting, which is a very important topic, and so that even if disintegration in the family is there, the family values could still be kept, because those mutual respect, mutual bonding, that could still be kept, even if we have differences in the families cropping up. And yes, definitely this needs to go out to the world at large, because the whole world, when we talk, mediation is not catching up that it's not that being explored. So when we are going to talk and we are going to have panel discussions, maybe between different professional groups, because like Bansuri was telling, I have not heard about it. So it's not going to be now a domain of only legal and mediation rooms. Let's bring it to those professional rooms where people are going to decide for themselves that this is the best path to go, conflict resolution peacefully. So, ladies, it has been, I think Dr. Wasim already left because
he did put in the chat box, he apologized for that.
Yes.
Yeah.
Yes. So, we couldn't thank him enough. So, but definitely, Janice, it has been a pleasure to host you. It has been really a wonderful experience, and I'm sure whoever will be listening will be, taking it really. Done.
Well, thank you so much for having me. It's been fantastic.
Pleasure, pleasure. And all you wonderful ladies, it's been a wonderful input and a wonderful session. So I'll just
Thank you.
Thank you.
thank you. I'll just stop the recording now. Lovely.